You good?
Yep.
Okay. My name is Polly Shoemaker. I'm the managing attorney of the Wisconsin Guardianship Support Center. The slide deck says POA for Healthcare Basics because I borrowed it from a different presentation, but I'll be talking about more than just the healthcare POA today. A little bit about me, just real quick, and the Guardianship Support Center. I do a lot of teaching and training on these topics. I have a helpline for questions on guardianship, advanced directives, anything and everything along those lines for adults. My main limitation is that I cannot provide legal advice or legal representation. So I will do my best to answer your questions. I can tell you what the law says and what it doesn't say. I cannot tell you what you should write on your form, but I'll do my best to answer questions. So when we talk about advanced directives, what are advanced directives? They're documents that allow you to tell your family, your friends, your providers, your banks, anybody and everybody who might need them, what you want if you're not able to communicate for yourself. We have several different kinds in Wisconsin. We have powers of attorney for healthcare and finance. We split them into two different documents. We also have living wills, which I'll talk about very briefly, and an authorization for final disposition, which I'll also talk about briefly at the end. We have a couple of other types of legal decision-making programs, supports, things like that. We have both supported decision-making and we have conservatorship or guardianship for people who are not able to put together advanced directives, or the advanced directives they created are not enough for what they need. Why do you need them? Because Wisconsin is, for the most part, not a next of kin state. I think a lot of people assume, we see it on TV, we hear from people in other states, oh, if my loved one is in the hospital, I can just make decisions for them. And that's not true here. And if I could do one thing to train everybody in Wisconsin, it would be, you can't do that here for the most part. So you have to have some sort of legal authority to be able to act on another person's behalf. That will either come from that person in the form of an advanced directive, or it will come from a court in a guardianship. And we don't want to have to do that. So it's a good idea to do your documents. Thank you for being here. So why do they matter? Because it gives you a chance to decide what you want, to make your wishes known, to decide who you want to make your decisions, who you want to handle your care decisions, who you want to handle your financial affairs, who you want to handle any end-of-life decisions, and you get to decide what that person can do and how much authority they have and what the limits of that authority are. With an advanced directive, the people you choose have to follow your wishes as expressed at any time, even if you're incapacitated, even if the only way you can communicate is by squeezing a hand or blinking or nodding. If you can make your wishes known, your agent must follow them. They don't get to override you. If you're not able to make your wishes known, then they must act in your best interest. If you don't have these documents and you can't make a new one or communicate your decisions, the court will choose a guardian for you. It may not be the person that you want, and they may not make the decisions you want them to make. A guardian does have the right to override in at least some situations. So this is why they matter to do them now. We do have supported decision-making. This was passed into law into 2018, which for me still feels kind of like it was yesterday because the last 5 years have just with everything. But anyway, supported decision-making is a formal agreement that allows you or any adult with a functional impairment to choose one or more people to support them in making decisions. Functional impairment is self-determined, so this could be mobility, it could be communication. My sister gets really bad migraines, and when she's got one, she's got really bad aphasia, she loses words. So she has a really hard time telling her providers what's going on, communicating what she needs at the doctor. She has capacity to make decisions, she just has a hard time communicating. So an agreement like this makes it possible for her to take someone with her to help her communicate. It's a way to have a formal support person with you. It's a way to have somebody get information from your providers, communicate information back to your providers without necessarily having to go through a whole lot of ordeal to do it. It's just a way to have some help. A supported decision-making agreement does not give somebody the power to make any decisions for you. They're just there to help you. And it can be a really good option if you have a new diagnosis, or you're really overwhelmed, or you're starting to have periods of incapacity, but you're not quite at the point where you need somebody full-time yet. It can be a really good way to get some support. And I think a lot of people just don't know that they're out there, so I want to try to make a point of mentioning it. So let's move on to power of attorney. A power of attorney, at its heart, is a legal contract between what's known as the principal, that's you, or whoever's document it is, they are the principal. It's a contract between you and the person you're choosing to make your decisions. That's your agent. A power of attorney can be created by any adult of sound mind, and the whole process has to be voluntary. So the decision to create the document, who you choose to make your decisions, and what decisions they can make, all get to be decided by you. Nobody can create a POA for you, and you can't create a POA for another person. You are the only one who gets a say in your document, and other people are the only ones who get a say in their document.
Okay.
Yes,
Can you have more than one person?
I will get to that.
Oh, sorry.
That's a really good question. Yes,
Will we get a copy of this information that you're giving us today?
I can send it to Kate.
Okay.
Yep.
Thank you.
Sure. A lot of this is on my website as well. This specific presentation is not, but the information is. And if you have internet access, that's a great way to get it. But otherwise, I can get the information to Kate and she can get it out. So what kind of decisions can your agent make? Only what the document allows them to do. And as I said, they have to follow your wishes as expressed at any time, either in your document or at any time after you've created it. So what does sound mind mean? This is a really good question, and it comes up a lot if people are asking, hey, so this person's power of attorney has been activated, their POA for healthcare is activated because they are not able to make their own healthcare decisions. What if they don't like their document anymore and they want a new one? What if they want to create a new document? I will tell you that not all lawyers agree that it's possible to create a new document if the previous one has been activated. I believe it is, and the Board on Aging and Long-Term Care does also. They've got a position paper on it that's got all the legal analysis. But essentially, sound mind is asking, do you know what you're signing at the time you are being asked to sign it? Do you understand the purpose of this document and what it does? That's all it is. So somebody might not be able to make complex healthcare decisions, but they might be very clear on who they want to make those decisions for them. So just so you know, though, that if you are in that situation, there is no guarantee that your providers will accept it. I think they should, but anyway, so it really depends on what the nature of that incapacity is and how it affects you at that point in time. Who's determining whether you're of sound mind? For a healthcare POA, that's your two witnesses. We are asking them to attest that you know what you're doing when you sign that document. For a financial POA, typically we would expect that notary to make that assessment. It's not a formal assessment. It's mostly just, is this document reflective of your wishes? Did you create it? Do you know what it does? So when you have a document in place, who makes decisions for you for healthcare? When the document has been activated, your agent makes the decisions. They make the decisions that the document authorizes, which is typically healthcare and healthcare only. For it to be valid, it has to be in writing, it has to be signed and dated by you, and it has to be signed by your two witnesses. Your witnesses must be disinterested, which means they are not your agent, not expected to inherit from you, not financially responsible for your healthcare, not your healthcare providers or employees of your providers. Basically that there's no conflict of interest where they might make decisions that are about them rather than about you. Who can be your agent? And this gets to your question. For a healthcare POA, the statutes say that a healthcare agent should be an individual, and we have generally interpreted that to mean somebody by name rather than the priest of my parish when it's activated, which we've seen, things like that. We want it to be a named specific person. You cannot choose a healthcare provider who is providing care to you unless they are related to you. So if you have an adult child who is a doctor and they work at a hospital and that's the hospital where you get care, you can choose them because they're related to you. But if your neighbor works at that hospital and is a physician, you can't choose your neighbor because they're not related to you. Unless you get care somewhere else, and then you can. Our statutes don't talk about co-agents for healthcare. Technically, it probably is possible. I think it's a best practice not to, because what happens if they don't agree? You can have a really big mess. You can also have situations where only one person is getting, or not both people aren't getting the same information. So provider A talks to agent A, and provider B talks to agent B, and is asking them to make decisions, but they don't have all the information. So it is possible. I don't recommend it, but it can be done. Generally, what I would suggest is having alternates, and you can have as many alternates as you want. That's for healthcare. For financial, it's a little bit different. Your agent for healthcare cannot choose their own successor or add any other agents. And I get that question pretty frequently on my helpline, especially if you've had a couple of agents pass away or they're incapacitated, they're not able to help, they're not willing to help, and you're down to the last one and they want to add another sibling or another family member. They can't, because you are the only one who gets a say in who your agents are. So how does it become activated? How does your agent get authority to act? By state law, activation is on incapacity. And incapacity is essentially an inability to not being capable of informed consent. So informed consent for healthcare means you can weigh the pros and cons of various treatments and decide between them which is best for you, that you have an understanding of your condition, you can apply those options to your condition. If you're not capable of informed consent for care, that's when this would be activated. By default in state law, it must be done by 2 physicians or 1 physician and an advanced practice clinician who can be a psychologist, a nurse practitioner, or a physician assistant. So, for example, if you have one of those for your primary care provider, they could be one of your activating providers potentially, or as stated on the document itself. So if you want something different, you can write that in. I do sometimes get asked if it's possible to have it be activated immediately without a finding of incapacity. State law does not talk about that. I have seen it occasionally, and there can be good reasons to do it. Again, if somebody is starting to become incapacitated, but it's really variable and they don't want to have to deal with activating, deactivating. It's also notable that some other states do specifically allow that. And the question is kind of always who gets to make decisions at the time. So I think technically it is possible if that's what you want. But supported decision-making can be a better option for some people depending on what your needs are and what you're looking for. And if you are wondering about that, I'm happy to talk it through with you after we're done recording. So what decisions can your agent make? You have become incapacitated, the document is now active. Your agent can only make healthcare decisions. That means care, treatment, services to address your health situations. It doesn't mean anything else, it's only healthcare. We have some specific directives in our healthcare documents. We want your agent to have specific authority before they can make a decision to withdraw or withhold feeding tubes from you. So you'll have the opportunity to check that box yes or no. Checking that box yes does not mean they must do it. It just gives them the power to do it at all, if that's what is appropriate for you. So that is something to consider. If you want it, but only in certain circumstances, you can write that into your document as well. And I'm happy to talk through that too. We do want your agent to have specific authority to be able to admit you to long-term care. So your agent has authority anyway to admit you to the hospital, to admit you to post-inpatient rehab. So if you have had a surgery or if you have had a hip replacement or something and now you need to be in a nursing home or a rehab center for a few weeks, your agent can do that. But if you're going to be there for long-term care for more than 60 to 90 days, then they have to have specific authority to do that. And you have the option to check that box, yes or no. If you leave it blank, it's the same as checking it no. And a lot of people have very strong feelings about it. I had a long conversation with my mom about it. She has said she does not ever want to go into a facility, no way, no how, for long-term care anyway. And so she checked the box no. And I said, you know, even if you check it yes, I still have to follow your wishes. So if you get there and say, nope, I'm out, I can't keep you there. She said, I know, but I don't want to risk it, which is fair. So if it comes down to that, if you decide you don't want your agent to have that power, and you get to a point where that's what you need in order to be safe and provide for your care, then we would have to go through the court to make that happen, to ensure that you have the opportunity to object, to have your objections heard, and have a court weigh in on whether it's really necessary. So you certainly can make your own decision on that. You also can decide whether an agent can make any decisions if you happen to be pregnant, if they know that you are pregnant, which may or may not apply to anybody in this room, but I mention it because it's on the form. So there are some decisions that a healthcare agent can't make because they're limited to healthcare. They don't get to make decisions about things like who can visit you. If you're in the hospital, if you're in a facility, if you're in your own home and getting in-home care, your agent doesn't get to decide, I got into a fight with my brother, so I don't think my brother gets to visit mom today. That's not up to your agent because it's not a healthcare decision. Healthcare decisions are about what you need to regain your health or stay at baseline or stay healthy. That's not what that is. They can't keep you in a facility against your wishes or keep you in a locked unit in a facility. You have to go through the court for that. They can't change health insurance for you or sign any financial documents. That would have to be your financial agent if you have one. They can't designate their own successor, and they cannot make any decisions after you pass away. They make healthcare decisions, and that's all. So what happens if your document was activated, but now you've regained functioning and you are back to being able to make your own decisions? We call that deactivation. That basically says, yep, this person can make their own decisions again. It leaves the document in place so it can be used again in the future if it's needed. There's no formal process in our statutes to do it. The statutes don't talk about it at all. So it really is up to healthcare providers, healthcare systems, hospitals, facilities, etc., to decide how they want to handle it. Most will have some variation on the reverse of the process to activate. Some will have it be, again, they want two providers to assess you and decide that you can make your own decisions again. Some will have it just be one. If it's after a hospital stay, they might want it to be your primary care. It really depends a lot. It's up to that facility, hospital, system, clinic, whatever, how they want to handle it. So you are ready to create your document. You've gone through it. You want to make sure that it's usable. Again, it has to be in writing. I once had a hospital ask about verbal POAs. It's not a thing. It has to be in writing. That's how we know it was you and your decision and that you knew what you were doing. It should name an individual person. You can name alternates, as many as you want. Again, my recommendation is that only one person should be able to act at a time for healthcare, because the consequences of disagreement can be pretty dire. If you cannot physically sign the document, you can direct someone to sign for you, but it must be in your presence and at your direction. So you have to be able to see them sign for you and say, yes, I cannot physically sign this document. Will you please do it for me? The witnesses must see you sign or see that person sign at your direction and should see you direct that signing if that's how you do it. Don't make any changes after signing. If you are unhappy with your document, I generally would recommend creating a new one. With the state form, it has a big page that says, notice to person making this document. You must keep that page with it. That's required by state law. It's in the packet for the form for today. Let's switch gears, talk a little bit about the financial form. If you have heard the term durable power of attorney, this is typically what it's referring to. The term durable is a legal term that means it stays in effect while you are incapacitated. That's not a requirement, it is the default in state law, but that's what that means. You retain the right to manage your own property and finances. It's not taking any rights away from you, but it allows somebody else to help, to act on your behalf. You get to decide when that happens. The default in state law is that it's active immediately when you sign it. There's no incapacity, nothing like that needed. But you can change that if you don't want that to be the case. So I've seen some people have it be on incapacity. I've seen some people have it be if they're traveling. If there's, say, somebody who's a snowbird, they spend 6 months in one state, 6 months in another state, they could have it be active while they're in the other state. They could have 2 separate documents, one in each state if they want, that are only active while they're not there or while they're there, however they want to do it. So it's pretty flexible as far as that goes. And if you have specific questions about that, I'm happy to talk about that at the end. When it is active on signing, again, it's not an indication that you can't manage your own money at that time. Mine was active the minute I signed it. I can certainly go to the bank for myself if I need to, but it allows my agent to do that too. So if I'm out of town or if I'm really busy and I can't get there to handle something, she can go and she can take care of it for me without me needing to be there. So with a POA for finances, this does allow you to have co-agents. If you choose to have co-agents for this document, you get to choose whether they can act independently or if they must act together. So if they have to act together, then both people would need to sign off on any particular transactions. You could have that be for just some kinds of transactions or property issues. You could have it be for everything. So that's up to you if you choose to have co-agents. You can also allow your agent to name their own successor for this. It's not allowed unless you specifically write it in. Both of these things you have to specifically write in. And for this, you don't have to pick an individual. You could choose somebody by office. So you could choose the trustee officer at the bank, or my financial advisor, or my tax guy, whoever that might happen to be at the time. You can do that for this. Strongly recommended to be notarized, not technically required, but I think there are no financial institutions that will accept it if it has not been. You don't have to have any witnesses for this. Also, since I mentioned financial institutions, you may sometimes run into issues where a bank or other organization will tell you that they won't accept your POA because it's not on their form. That is not legal under state law. They cannot reject your POA for the sole reason that it's not on their form. They have to find some other reason for it to not be valid. If that happens, my general recommendation would be to escalate it within the entity if you can. Write a letter to their counsel, ask for an explanation in writing. Why are you violating state law? That's what I would do, but I'm a lawyer, so I like that kind of letter. But certainly there are some options there because it is a requirement in state law that they accept it unless there's some other reason for it to be not valid.
You could have yours and then fill out theirs and just have them
You could.
join together.
You could. I just don't think it's necessary, and I get sticky about that. But yes, you could, for the recording, in case that wasn't audible, yes, you could fill out the bank's form and have it be alongside this one. That is an option. If that's what it takes and that's what you want to do to make it easier for everybody, yes, you could do that. I get questions sometimes about agent liability. An agent will ask, am I responsible for paying this person's bills out of my own pocket? No. You are responsible for handling that person's money out of, or handling their bills, whatever it happens to be, out of their money. If they don't have enough money to do it, that's not really your problem. There might be steps that you can take on their behalf to help deal with that, but it does not mean that you have to then make up the difference out of your pocket. You are paying for whatever it happens to be, or doing the transactions out of their funds. You are handling their money for them. It's not obligating you. So if you are acting as agent for somebody, I would always recommend that you sign specifically as agent. You know, Jane Smith, agent for John Smith, or whatever it might happen to be, to make it very clear that you are not obligating yourself in your personal capacity. You are acting as their agent on their behalf. So you are ready to fill out your form. You want to make sure that it will be accepted. Again, it has to be in writing. If you are using the state form, it has a series of checkboxes that talk about the different kinds of authority you can give your agent. If you haven't looked at it before, you'll get the chance today, but it's things like handling real estate, handling insurance, handling personal and family maintenance, a whole bunch of different stuff on there. We can talk through it if you've got questions about what those mean. You have to check those boxes or initial those boxes if you want your agent to be able to handle those things. If you sign the form and you have not initialed anything, your agent really can't do much. So think about what you want them to do and initial those boxes. I have a copy of the statutes on my iPad that I can bring up. If anybody wants to see exactly what those things mean, we can talk about it. Because you can have more than one financial power of attorney at a time, if you already have one and you want your new one to revoke the past one, you need to write that in. It has to specifically state that it revokes past POAs. Otherwise, they'll both be in effect. If there's conflicts, then usually, well, it depends on exactly what the conflict is. Sometimes it requires going to court to sort it out. Some providers or banks will simply look at the newer one as your intent. Either way, if you want the old one to be gone, write in the new one that you want it to revoke past documents. If you do want multiple documents, again, you can do that, but make sure they don't conflict. And if you have specific questions or a specific situation, I'm happy to try to answer, but I may end up referring you out to a private attorney to discuss what is best for you. Power of attorney documents have some legal safeguards. So you've got this document in place, you want to make sure that your agent can't abuse their authority. Interested parties can petition for court review, so that could be family members, it could be providers, it could be anybody who has a concern about what's going on and an interest in whatever's happening. A court can determine whether that POA is valid. If there are competing documents, they can determine which one is valid. They can review what the agent has done. If they don't think the agent is acting appropriately, they can order them to follow the document, order them to report to the court. They can remove them and put in an alternate if there are any left on your list. If your financial agent has misused your funds, they can require them to pay that back. So there are some options there to protect you for a court to review and to look into that. And just because you've named somebody as your agent does not make them necessarily immune from something like criminal prosecution if they run away with all of your money. So you've got that protection too, but it depends a little bit on how you've worded your document. State law for a financial document does prevent your agent from doing any gifting of your money to anybody else or self-dealing. So they can't take all your money and use it for themselves unless you explicitly give them permission to do that, and most people don't. If you happen to have documents from other states already and you're not sure whether you need to create a new one, we do recognize documents from other states. The signature requirements might be different, that's okay. The activation requirements might be different, that's okay. Providers and anybody else should follow that document. Where it sometimes becomes an issue is on the healthcare side. Because our healthcare POAs have those specific requirements for long-term care admission, end of life, if the document from the other state does not have any language about those things that would authorize that, it does not make the POA invalid. It just means the agent can't make that decision. So it would be the same as if you checked the no box on the Wisconsin form. They can still do anything else that they would be able to do under Wisconsin law that your document authorizes. Couple more things here, and then we can get to actually working on them and any questions. Don't make changes to your document after the fact. Even if somebody's contact information has changed or somebody's name has changed, somebody gets married or divorced, or changes their name just for the fun of it, you don't need to update your document for that. If you do want to have the new information available, I typically recommend writing it down on a separate piece of paper, signing, dating it, attaching it to the original document, so that you've got that information there, but you haven't made any changes to the original. If somebody's phone number has changed, same thing. You can put the new phone number on a separate sheet of paper, so at least it's available, but don't make changes to the actual document. When does an agent's authority end? If your document is activated on incapacity, if you regain capacity, your agent can no longer act. If you set up your financial POA so that it took effect on some specific event, like travel, then it will expire when you come back. The document will still be there and can be used again in the future. It's just that the agent can't act right now because whatever event triggered their authority has ended. If you revoke your document, your agent cannot act. That gets rid of your document, it's gone. If your agent resigns, they can't act. If an agent is removed by a court, they can't act. If your agent dies, obviously they can't do anything for you. If you die, your agent cannot act. Their authority ends when you pass away. It may end if a guardianship is imposed. It depends. If you've got questions about that, we can talk about it. So how do you revoke a POA if you decide you're not happy with what you've got? For healthcare POA, creating a new one will automatically revoke your past healthcare POA. So that's the simplest way. Oh, I don't like what my agent is doing, or all of my agents are no longer available or willing, so I need to name new people. I will simply create a new document. Boom, you're done. You can also revoke it in writing. You can simply write a statement saying you wish to revoke your POA, sign it, date it. You can state in front of 2 witnesses that you want to revoke your healthcare POA. That'll do it. You can tear it up, deface it. And this is why we say don't make changes on it, because we don't want that to be mistaken for defacement. Burn it, whatever you need to do to destroy that document, that will do it as well. And as I noted, the new a new financial POA does not automatically revoke past ones, but if you write in there that it does, then it will. I'll talk very briefly about the other kinds of advance directives that we have. A living will, also called a declaration to healthcare professionals, is basically just a directive to your providers of what you want to have happen in certain end-of-life circumstances. So if you are in a persistent vegetative state, or if you have a terminal illness and you are not able to make your own decisions, your providers can carry out your wishes to either withdraw or withhold feeding tubes and other life-sustaining treatment, or continue those as you've chosen in your document. Does not designate agents, does not give any other power. So you might ask, why have one if you have a healthcare POA? I think it can be a really handy backup in case your agent is not available or not willing to make that decision. Just to have something in place so that somebody knows what you want and can carry it out just in case. You don't have to have one though. And if you do have a healthcare POA, your agent will have a lot of that authority anyway. It also requires 2 witnesses to be valid. Authorization for final disposition is a document that allows you to state what you want for funeral, burial, cremation, etc., what happens to your body after you have passed away. You can put down specifically what you want to have happen. You can put down who you want to handle that decision. If you have any special requests or if you have any funds or anything set aside, it's a way to also let your representative know where those are and how to find that information. Requires 2 witnesses or a notary. Your representative does need to sign it before they can act, but they don't have to sign at the same time as you. So this is not required. If you pass away, you don't have this document in place, our statutes provide a priority list of who can act. Typically, it will be your spouse, then adult children, then siblings, I think is the order, then other family members, then a guardian, then anybody else who's willing. So the statutes would go through that list, to find somebody who is willing and able to make those decisions. So if you don't have it, you're still covered. But if you have a specific person in mind or you have specific wishes, this is a good way to document that. And I have occasionally talked to people who are estranged from family. This is a good way to make sure that they can pick who they want and their family isn't the one making the decision for them. Okay, you've done your documents. Now what? Copies are as good as the original, so you can make as many copies as you need. I always suggest keeping your originals in a safe place. Some counties allow you to deposit it with probate for a small fee. I think it's $8. I think Dane does this. I don't remember off the top of my head. There's pros and cons to that. The biggest disadvantage is that it's only available when the court is open. So if it's a weekend and your agent needs to act and the document is in the courthouse, they're kind of out of luck, and so are you, unless you've got another copy somewhere else. But it can be a way to at least have a copy somewhere safe where somebody can get it if they need to. And typically access to that would be limited to you and to your agents. You should give a copy of your healthcare POA to your healthcare providers. If you create a living will, give them that also. Typically, they will scan it and put it into your electronic medical record and then give you back the original. You can give copies to your agents. You don't have to, but you should at least tell them where they can find it so that if it's needed, they won't have to be digging and say, I know mom had a POA, but I don't know where to find it and nobody else has it. I don't know what to do, because then everybody's out of luck. So make sure that they at least know where to find it. Don't send it back to the Department of Health Services. They will send it back to you. So keep it in a safe place. If you put your financial POA in a safe deposit box, you need to make sure that either your agent has access to the box or somebody else has access to that box. Because if the document that authorizes them to access the box is in the box, they have a problem. They will not be able to get it. Mine is in my safe deposit box, but I share my safe deposit box with my agent. So, and also she has a copy. You can also scan it. You can keep it in something like Google Drive or Dropbox or iCloud. If you want to do that, you're certainly able to do that and then just print it out as needed. So that's an option as well. And I did that for mine also, just in a pinch. So that's what happens when they're done. If you have questions beyond what can be answered here, here is my contact information. Feel free to reach out. Again, I am limited to what is in state law, but I'm happy to try to answer questions where I can. And this will be, if you get home and you think of a question that you forgot to ask, or you have something that you don't want to ask here in front of everybody, feel free to reach out. So now, I think Kate's turning off the recording and then we can take questions.